Hello my dear students, I know everyone will be preparing for the examination which is going to be conducted on 15th of July 2023. So in this session we will be having a small discussion on the amendments which is applicable to corporate and economic laws, paper 13 of your CMA final. So the discussion will be applicable for the students who are appearing under 2016 syllabus in their paper corporate laws and compliances. So I have divided the discussion into certain parts. So we will move to first part. So the first part is related to incorporation of companies. Under incorporation of companies we are having three amendments. Number 1 related to small company, number 2 incorporation of one person company, number 3 conversion of one person company. So with respect to small company, there has been an amendment with regard to its paid up capital and turnover. So as per the amendment, a small company is a private company whose paid up capital does not exceed rupees 4 crore and turnover does not exceed rupees 40 crore. Okay. Then we are moving to the amendment related to incorporation of OPC. One person company can be incorporated by a natural person who is citizen of India, and that person may or may not be resident in India. So with respect to resident in India, the amendment says that a person who has stayed in India for a minimum of 120 days during the immediately preceding financial year will be said to be resident. Okay. With respect to conversion of OPC, one person company can now be converted to private or public at any point of time. So earlier there was a time limit of 2 years completion, and or the condition was if certain thresholds are crossed, they have to be mandatorily converted to private or public. That has been deleted. So now one person company can be converted to private or public at any point of time. Okay. So now we will move to the chapter meetings of board and its powers. So under this chapter we are having three amendments. Number 1 related to thresholds in related party transaction. Number 2 amendment or omitting of rule number 4. Number 3 the amendment which is related to constitution or applicability of audit committee and nomination and remuneration committee. First we will move to related party transaction. So we know that related party transaction requires either board's approval or approval from members by way of ordinary resolution. So if transaction, individual transaction or aggregate transaction in a financial year equals or exceeds or certain thresholds, ordinary resolution is required. Okay. So the amendment is related to that threshold. So if the transaction, individual or aggregate transaction in a financial year is related to sale, purchase or supply of material, the new threshold is 10% of turnover. That means if individual transaction or aggregate transaction related to sale, purchase or supply of material is equal to 10% of turnover or exceeds that, ordinary resolution is required. For other transaction only board's resolution is required. So related to selling, disposing or buying of property, the new threshold will be 10% or more of net worth. If the transaction is related to leasing of property, the new threshold is 10% or more of turnover. And if the transaction is related to availing or rendering of services, the new threshold will be 10% or more of turnover. Okay. So we will move to omitting of rule 4. Earlier under rule 4 it was specified that the mentioned transaction like approval of financial statement, board's report, prospectus, then consideration of financial statement, approval regarding merger, demerger, acquisition, takeover. So board meeting with respect to or board meeting in which these discussions are planned, that could not be conducted through VC or other audio visual means. VC stands for video conferencing. Okay. So that rule has been deleted. So it is now possible to conduct a board meeting in which the following or in which these 5 items are planned to be conducted in video conferencing or other audio visual means. Okay. Now the non-applicability of audit committee and nomination and remuneration committee. So we know that audit committee and nomination and remuneration committee is applicable to 2 sets of companies. Number 1, listed public company. Number 2, unlisted public company which is having paid up capital 10 CR or above, or turnover 100 CR or above, or aggregate outstanding loan debenture deposit in excess of 50 CR. Okay. So if an unlisted public company to whom audit committee or nomination and remuneration committee is applicable fails to meet the criteria, fails to meet the thresholds like 10 CR or above paid up, 100 CR or above turnover, exceeding 50 CR loan debenture deposit. If they fails to meet these criteria for 3 consecutive years, they will not be required to constitute audit committee or nomination and remuneration committee in the next financial year. Okay, that is the new amendment which is provided in the provision. Okay, so this provision is also applicable for independent directors also, because independent directors applicability is also based on the same threshold. Okay. Next is under the chapter acceptance of deposit. Acceptance of deposit has one amendment. Actually, this is not an amendment. This provision is shown incorrectly in the study material. So that is the reason why I have included this provision here. So one is related to deposit repayment reserve. Next one is acceptance of deposit by private limited company. So for deposit repayment reserve, minimum 20% of the amount which is maturing in the financial year to be maintained as deposit repayment reserve, and deposit repayment reserve has to be maintained on or before 30th of April every year. Okay. So I think in the material it is given as 15%. That was the old provision. Now I think 2 or 3 years back it was amended to 20%. Next is related to acceptance of deposit by private limited company. We know that 2 companies can accept deposit from members. Number 1 is eligible public company. They can accept maximum of 10%. The second company is ineligible public company, or companies which are specified in 73 subsection 2. They can accept up to 25%. Okay. So for private company can accept maximum of 100% of paid up free reserves and security premium from their members. Okay. If you want to accept deposit from public, there is only one company which can accept deposit from public, that is eligible public company. Okay. Then next is related to the amendment in Insolvency and Bankruptcy Code 2016. So there are 2 amendments. One is in section 11, person who cannot initiate insolvency resolution. Number 2, time limit for completion of CARP. This is an amendment which took place in I think 2021, but again in study material it was given wrong. Okay. So first we will move to section 11. So person not entitled to make application. So corporate debtor undergoing corporate insolvency resolution or pre-packaged insolvency resolution process, which I have given in red is the amended part. Number 2, financial creditor, operational creditor or corporate debtor undergoing pre-packaged insolvency resolution process. Corporate debtor having been completed CIRP 12 months preceding date of application. Corporate debtor in respect of whom resolution plan has been approved 12 months preceding date of application. Corporate debtor or financial creditor who has violated the terms of resolution plan approved 12 months before date of application, and corporate debtor in respect of whom a liquidation order has been passed. Okay. So with respect to time limit for completion of CARP, this is actually 330 days. We know that CIRP has to be completed within 180 days. Then one time extension is possible after application to NCLT, 90 days will be given, and including the time taken for any legal proceeding, the maximum time limit is 330 days, but in material which is given as 360 days. So that is the reason why I have included the provision here. Okay, so now we will move to the amendments related to Sebi. So the amendments are person who is not or who are not eligible to make IPO, FPO, then related to lock-in period for minimum promoter contribution, excess over minimum promoter contribution, then appointment of monitoring agency. So most of these provisions are specified in Sebi ICDR regulation 2018. So in ICDR, person who are not eligible to make IPO or FPO is there. So in that, willful defaulter is substituted by willful defaulter or fraudulent borrowers. Then number 2, amount of general corporate purposes in IPO, FPO shall not exceed 35%. Earlier it was 25%, now it is raised to 35%. Then cap on price band shall be minimum 105% of floor price. Earlier it was 120%. Promoters lock-in period is reduced to 1.5 years, 18 months, it was earlier 3 years. Then lock-in period for amount exceeding promoter contribution is reduced to 6 months from the period of 1 year. Then for issue size exceeding rupees 1 crore, monitoring agency has to be appointed. Earlier it was bank or public financial institution. Now the provision has been amended. Now we have to appoint credit rating agency as monitoring agency if the issue proceeds exceeds rupees 100 crore. Okay. So these are the major amendments which is applicable for the examination, which is going to be held on 15th of July 2023. Okay. So I wish all the students the very best, and we will be coming with a new topic in our next session. Okay. Thank you. Take care.